Hey everyone, it's TheRealLauraB from here on YouTube and Twitter, and this is a very quick response. Johnny has filed his final reply on his appeal. He filed for an appeal. Amber Heard responded. There were no amici briefs assigned to this. This was pretty straightforward. Johnny has now given his final reply, and that's what we're going to get started with now.
Hi, I'm Laura, also known as TheRealLauraB from Twitter, and now here on YouTube. I'm a researcher, new wave internet media, and commentator. I'm not a lawyer nor offering any legal advice. Join me on a journey to review the world of celebrity lawsuits and current events. Let's get started.
Yes, let's get started. Let's get right into it. This was just filed today at 3 o'clock. 3 o'clock. I just got it. So here we go. This is his final reply. Table of contents. She mischaracterizes the jury's finding. Oh, hell yes, and verdict. Reliance on vicarious liability based on agency is inappropriate for the attorney-client context. Ms. Heard failed to establish malice, actual malice. Waldman Statement is properly understood as opinion, and the court should have instructed the jury on independent contractor theory, and the trial court should have admitted the entire article because it's all about context. It's all about rebuttals back and forth. That's my opinion. So here we go. Table of authorities. Again, lots of cases. Let's go back and see. Virginia, U.S. 8th Circuit, Virginia, 7th Circuit. So we will say Virginia. I'm not going to go through the cases. And then the restatements and agency. Introduction. In her appellee brief, Heard brief, or HB, Ms. Heard misapplies the law and misstates the findings of the jury, attempting to distract the court by re-arguing factual disputes that the jury emphatically resolved in favor of Mr. Depp. In fact, this appeal presents the court with only a few narrow legal issues, each of which warrants the reversal of the lone portion of the judgment in favor of Ms. Heard on her counterclaim. First, can a client be held vicariously liable under a pure agency theory for the allegedly torturous conduct of his attorney? Long-standing principles limiting liability for the acts of independent contractors dictate that the answer is no, when, as here, no evidence of additional torturous conduct by the client was presented. Second, did Ms. Heard present any evidence to show that Mr. Waldman made the April 27th Waldman Statement with actual malice? Again, the answer is no. Ms. Heard presented no evidence, much less clear and convincing evidence, of Mr. Waldman's state of mind. She argues she can fill in the blank with evidence of Mr. Depp's state of mind, but that argument fails as a matter of law. Footnote, Ms. Heard asserts that evidence of direct liability was presented as well, as explained below. Ms. Heard is wrong. Capitalized terms not defined herein are ascribing the meaning set forth in Mr. Depp's appellant brief. So referring back to his original brief. Regardless, Ms. Heard presented no evidence that Mr. Depp even knew that the statement had been made, much less that he contemporaneously, oh God, knew it was false. Ben, give me a break. True, Johnny testified that he didn't know anything about these statements until he was sued, the counterclaim. Third, in context, should a comment by Mr. Waldman to a well-informed journalist about the inferences to be drawn from conflicting evidence in contested litigation be properly understood as factual statements sufficient to state a claim for defamation? For the third time, the answer is no. The April 27 Waldman Statement in context is nothing more than a theory proffered by a speaker with a disclosed bias discussing an interpretation of ambiguous subject matter about which he claimed no firsthand personal knowledge. The court should uphold the judgment in most respects, but reverse as to the sole finding in Ms. Heard's favor on the April 27 Waldman Statement. Let me restate that. The court should uphold the judgment in most respects. That's the 2 out of the 3 statements that they found in favor of Depp. But reverse as to the sole finding in Ms. Heard's favor on the April 27th Waldman Statement. Argument. Ms. Heard characterizes the jury's finding and verdict. Repeating factual claims that were unambiguously rejected by the jury, Ms. Heard takes the untenable position that the evidence at trial established that in May 2016, the parties' marriage was falling apart due to Mr. Depp's alcoholism, drug use, and abuse of his wife. Bafflingly, Ms. Heard spends many pages of her brief reciting a litany of her factual claims that were necessarily found to be false by the jury. Now, when they refer to factual claims, it's fact versus law. Remember, the jury determines they're the fact finder. So when they're saying she's making factual their claims, they're not saying they are in fact, credible and believable. That's just saying factual claims versus the legal, which is what the judge decides. Her brief reciting a litany of her factual claims that were necessarily found to be false by the jury in a wholly inappropriate attempt to re-argue the facts of this case. Heard's brief. Pages 1 through 12, by the way. Ms. Heard's arguments fail the straight-face test. The jury found in favor of Mr. Depp and against Ms. Heard on virtually all material points in dispute. In finding that Ms. Heard defamed Mr. Depp, the jury necessarily found that Ms. Heard's statements that she was a public figure representing domestic abuse, who had spoken up against sexual violence, made a false implication about Mr. Depp, and that Ms. Heard acted with actual malice when she made these statements, meaning she knew the implication was false. Consistent therewith, the jury also found that Mr. Waldman's statements that Ms. Heard's abuse claims were a perjurious hoax and fake sexual violence allegations did not constitute defamation against her. The sole statement on which Ms. Heard prevailed involved additional theorizing by Mr. Waldman that on May 21, 2016, Ms. Heard and her friends had set Mr. Depp up by calling the cops, spilled a little wine, and roughed the place up, got their stories straight under the direction of a lawyer and publicist, and then placed a second call to 911. The only intellectually honest interpretation of the verdict is that the jury found Ms. Heard's claim that she had been abused by Mr. Depp was false, but also found that she had not conspired with her friends, a lawyer, and a publicist to create a fake crime scene for police officers on May 21, 2016. Ms. Heard's attempt to recharacterize the verdict as consistent with her claims of abuse is untenable and should not be countenanced. 2. Ms. Heard's reliance on vicarious liability based on agency is inappropriate in the attorney-client context. An attorney is properly understood as a non-servant agent, i.e. an independent contractor. We go with that master-servant again, the old language, master being the boss. Ms. Heard's brief proceeds from the flawed premise that she can prove Mr. Depp's liability merely by establishing that Mr. Waldman was his agent. Ms. Heard misses the point. The question is not whether Mr. Waldman is an agent, but rather what type of agent he is, an employee agent or a non-employee agent, i.e. an independent contractor. Virginia law has long drawn a sharp distinction between employees and independent contractors when imposing vicarious liability. See McDonald's Hampton Training School for Nurses. This reflects the well-recognized principle that it is reasonable to impose liability on a principal for the actions of another person if that person is under the principal's control in a meaningful sense, but not otherwise. In other words, the logic of generally holding employers liable for the torts of their agents or employees is simply that when employers have the right to control their employees, they are, at least theoretically, in a position to prevent them from committing torturous acts. The less control an employer can exercise, the less strength that logic has. The crucial question is whether the employer had the right to control not merely results, but the progress and the details of the work. Although the Virginia Supreme Court has not squarely considered the type of agency that exists between an attorney and a client, there are substantial reasons to adopt the view of multiple other jurisdictions that attorneys, while undoubtedly agents of their clients for certain purposes, are presumptively non-servant or independent contractor agents. This is because attorneys are required to exercise independent professional judgment and are subject to independent professional and ethical obligations. Though guided by their clients with respect to ends, attorneys have wide discretion over means. These factors preclude the level of control by a client that would justify the imposition of vicarious liability for an attorney's intentional torts. Agency is a fiduciary relationship arising from the manifest of consent by one person to another that the other shall act on his behalf and subject to his control, and the agreement by the other so to act. Internal quotation citations omitted, sorry. Importantly, the control a principal exercises over its agent is not defined rigidly to mean control over the minutiae of the agent's actions, such as the agent's physical contact, as is required for the master-servant relationship, and may be very attenuated with respect to the details, though the principal must have ultimate responsibility to control the end result of his or her agent's actions. An independent contractor is a person who contracts with another to do something for him, but who is not controlled by the other nor subject to the other's rights to control with respect to his physical conduct in the performance of the undertaking. He may or may not be an agent. While it is always the case that an independent contractor is not a servant, it is not always the case that an independent contractor is not an agent. An agent who is not a servant is, therefore, an independent contractor when he contracts to act on the account of the principal. It is thus unsurprising that courts in numerous jurisdictions have concluded that one can be both an agent and an independent contractor with corresponding limitations on vicarious liability principles. Ms. Heard incorrectly claims that Mr. Depp is arguing that Mr. Waldman is either an independent contractor or an agent. Ms. Heard also appears to suggest that the finding of an agency relationship is incompatible with independent contractor status. Footnote, Ms. Heard's exact argument is somewhat opaque. At one point, she appears to suggest that a person's status as an independent contractor precludes the existence of an agency relationship on page 19, while elsewhere stating that Mr. Waldman can be both an independent contractor and an agent on page 20. The latter statement is correct. Thus, she argues because Mr. Waldman is an agent, an adequate basis for Mr. Depp's vicarious liability has necessarily been established irrespective of whether Mr. Waldman was an independent contractor. Ms. Heard, for instance, cites this case for the proposition that vicarious liability for an independent contractor's conduct is permitted based on agency principles. But the theory adopted by that court was that the employer of an independent contractor physician could be held liable under the doctrine of apparent authority, a position that has not been adopted in Virginia in the context of tort claims. Moreover, Petrovich did not involve an attorney-client relationship, and other cases from the same jurisdiction that have considered that issue have concluded that attorneys are independent contractors whose clients are not automatically liable for their torts. In this case, as follows. A person may be both an independent contractor and an agent with the authority both to control the details of the work and also the power to act for and to bind the principal in business negotiations within the scope of the agency. As a general rule, attorneys fit squarely within this category. Nonetheless, when attorneys act pursuant to the exercise of independent professional judgment, they possess such considerable autonomy over the details and manner of performing their work that they are presumptively independent contractors for purposes of imposing vicarious liability. Accordingly, where a plaintiff seeks to hold a client vicariously liable for the attorney's allegedly intentional torturous conduct, a plaintiff must prove facts demonstrating either that the client specifically directed, controlled, or authorized the attorney's precise method of performing the work, or that the client subsequently ratified acts performed in the exercise of the attorney's independent judgment. The court in Horowitz also noted the importance of attorneys' ethical obligations, which severely limit the level of control that clients can exercise over them. Attorneys are constrained by certain court-imposed ethical considerations that serve to distance their behavior from their clients. Thus, attorneys cannot blindly follow their clients' directions, even if those directions are particular and express, if doing so would require them to violate their ethical obligations. So it seems like it should be a two-way street, right? If a client can order their attorney to do something that they know is unethical as an attorney, then vice versa. Attorney shouldn't be bound. I mean, the client should not be bound for what an attorney independently decides to do. Although there are some jurisdictions that will impute torturous conduct from an attorney to a client based solely on the agency relationship, numerous courts have concluded that agency alone is not sufficient because attorneys are independent contractors with considerable autonomy and discretion over the conduct of their representation of clients. A defense attorney as an independent contractor has discretion regarding the day-to-day details of conducting the defense and is not subject to the client's control regarding those details. That approach is most consistent with the core premise of vicarious liability, i.e., that it should be based on the right of the principal to control the agent and prevent torturous conduct. The court should adopt that approach here. Ms. Heard's vicarious liability theory is particularly inapposite in the defamation context. Whether Mr. Waldman was an independent contractor is an especially critical inquiry in the defamation context. Several courts have concluded that the First Amendment restricts imputation of actual malice in the absence of an employer-employee relationship, and that the existence of a mere non-servant agency relationship is not sufficient. For instance, the U.S. District Court for the Eastern District of Virginia has stated, with respect to the agency theory, it is well established that actual malice must be proved with respect to each defendant. Although reckless disregard may be imputed to a defendant under respondent superior, multiple courts have held that the actual malice cannot be imputed from one defendant to another absent an employer-employee relationship. In this case, the imputation of actual malice was examined at some length by the court. The question in McFarlane was whether the malice of a non-employee agent can be imputed to the principal. The court noted that in the seminal case, New York Times versus Sullivan, the United States Supreme Court had refused to impute to the individuals as principals any information in the minds of persons they authorized to act as their agents in the matter. And the federal courts commonly interpret the Supreme Court's holding in Cantrell v. Forest City Publishing as barring liability on any theory other than respondent superior, which is limited to employees. Ultimately doubted that actual malice can be imputed except under respondent superior, and held that a principal's malice could only be established through evidence of the information available to and conduct of its employees. As even Ms. Heard appears to concede, Mr. Waldman was never Mr. Depp's employee, and respondent superior does not apply. Ms. Heard did not establish that Mr. Depp directed, controlled, or authorized the April 27th Waldman Statement. Because liability based solely on Mr. Waldman's status as Mr. Depp's outside attorney is inconsistent with longstanding Virginia principles limiting the liability of employers of independent contractors, especially in the context of the First Amendment, Ms. Heard should have been required to establish torturous conduct by Mr. Depp beyond merely employing Mr. Depp as an attorney. Ms. Heard did not do so. Although Ms. Heard makes the conclusory assertion that Mr. Depp entrusted Mr. Waldman to be his mouthpiece, this is a quote, entrusted Mr. Waldman to be his mouthpiece in continuing to defame Ms. Heard through public statements, quote, there was no actual evidence of that in the record. Indeed, in response to questioning from Ms. Heard's attorney, Mr. Waldman made clear that his relationship with Mr. Depp is simply that of an attorney. Footnote. Ms. Heard appears to take the position that speaking to the press presumptively falls outside the normal attorney-client relationship. Though Mr. Waldman acknowledged speaking to the press on several occasions, that does not constitute evidence that Mr. Depp was involved in the April 27 Waldman Statement. Ms. Heard offered no evidence that Mr. Depp directed or had any involvement in making the April 27 Waldman Statement. These footnotes are important. Ms. Heard cites a meeting with an unnamed representative from the Daily Mail on February 17, 2020, more than 2 months prior to the April 27 Waldman Statement, at which Mr. Depp may have been present. At trial, no evidence was presented as to what was discussed at the meeting or the identity of the Daily Mail representative. That meeting is not evidence of anything. Rather, the uncontroverted evidence at trial was that Mr. Depp did not even know the statement had been made until Ms. Heard commenced this action. The sole basis of finding liability against Mr. Depp based on the April 27 Waldman Statement was, therefore, that Mr. Waldman was his attorney and agent. Such a finding is inconsistent with legal principles applicable to the independent contractors and should be rejected. Ms. Heard failed to establish actual malice. Point 3. Ms. Heard was required to show that Mr. Waldman, in italics, made the April 27th Waldman Statement with actual malice. It is well established in Virginia law that a claim cannot proceed against an employer or principal based on an employee or agent's conduct without a showing that the employee or agent committed a tort. A claimant cannot make out a vicarious liability claim against an employer without first proving that the employee committed a tort within the scope of his employment. These are cites from cases. Another case, it is well settled in Virginia that where a master and servant are sued together in tort and the master's liability, if any, is solely dependent on the servant's conduct, a verdict for the servant necessarily exonerates the master. Ignoring these authorities, Ms. Heard argues that the court can find a complete tort by mixing and matching the conduct of both principal and agent. Here, that means stitching Mr. Depp's supposed state of mind onto Mr. Waldman's conduct to find against Mr. Depp, even if Mr. Waldman's conduct did not satisfy all elements of the tort of defamation. This is not permitted under Virginia or any law. Ms. Heard's sole basis for her theory is language in the restatement indicating that a principal can be held directly liable for agent's conduct that is within the scope of the agent's actual authority or ratified by the principal. If the agent's conduct, if that of the principal, would subject the principal to tort liability. Restatement. Ms. Heard, however, omits the restatement definition of actual authority, which provides that an agent acts with actual authority when, at the time of taking action that has legal consequences for the principal, italicized emphasis, the agent reasonably believes, in accordance with the principal's manifestations to the agent, that the principal wishes the agents so to act. There are multiple problems with Ms. Heard's argument. First, it runs contrary to well-settled Virginia authorities, including those noted above, that make plain that the liability of a principal or employer is contingent on a showing that the agent or employee committed a tort. Indeed, the Supreme Court of Virginia noted as recently as 2018 that, and this is a quote, if a mere employee commits the torturous conduct, the corporate employer will not be subject to direct liability, technically speaking, but rather only to the respondent superior liability. In other words, absent a showing that Mr. Waldman was acting at Mr. Depp's specific direction in making the April 27th Waldman Statement, which is nowhere in the record, Ms. Heard is limited to vicarious liability. Second, the portion of the restatement cited by Ms. Heard does not salvage her argument because there is zero evidence that Mr. Waldman's statements were directed by Mr. Depp, i.e., were within the scope of his actual authority. Ms. Heard has not cited to any evidence in the record of any manifestations from Mr. Depp to Mr. Waldman instructing him to make the April 27th Waldman Statement, such that Mr. Waldman reasonably believed Mr. Depp wanted him to make the April 27th Waldman Statement. Nor has Ms. Heard identified any evidence in the record that Mr. Depp ratified the April 27th Waldman Statement. Third, even overlooking those defects, actual malice requires a clear and convincing evidence of contemporaneous knowledge that a statement is false or probably false. Mr. Depp's uncontroverted testimony was that he had not seen the April 27th Waldman Statement prior to this litigation, and the jury received no evidence to suggest he contemporaneously knew it had even been made. Thus, even if Mr. Depp's state of mind could theoretically be mixed and matched with Mr. Waldman's conduct to create a single Frankenstein tort, there's no evidence from which it can reasonably be inferred that Mr. Depp had the requisite state of mind, i.e., that he knew the April 27th Waldman Statement was false when it was made, because he did not even know it had been made. Ms. Heard failed to show that Mr. Waldman made the April 27th Waldman Statement with actual malice. Even assuming that the tort could somehow be imputed to Mr. Depp, Ms. Heard was required to establish that Mr. Waldman made the statement with actual malice, meaning he subjectively knew that it was false or probably false. Citing from a case, in order to establish actual malice, a plaintiff must demonstrate by clear and convincing evidence that the defendant realized that his statement was false or that he subjectively entertained serious doubt as to the truth of the statement. Evidence of mere hostility, failure to reasonably investigate, or lack of prudence are not sufficient. Ms. Heard never presented any evidence of Mr. Waldman's state of mind that would permit the conclusion by clear and convincing evidence that he believed that any of his statements were false. Ms. Heard is unable to come up with any serious argument to the contrary. She argues that Mr. Waldman could not have simultaneously believed that there was no damage to the penthouse and that Ms. Heard caused damage to the penthouse described in the April 27th Waldman Statement. This argument is contradicted by evidentiary record. At trial, Ms. Heard asserted that there was evidence of damage to her penthouse. supposed damage that Mr. Waldman explained in his statement by suggesting that she had done it herself, while noting that the police officer called to the premises had seen nothing that supported her allegations. This is not clear and convincing evidence that Mr. Waldman subjectively believed his statements was false. To the contrary, the evidence overwhelmingly indicates that he believed what he said. Similarly, Ms. Heard complains that Mr. Waldman selectively credited only the evidence he believed was favorable and ignored the abundance of evidence of Mr. Depp's abuse of Ms. Heard. Again, this is a feeble argument and directly contradicted by the findings of the jury against Ms. Heard. Mr. Waldman is entitled to make value judgments about the weight of the evidence, just as the jury did, and both Mr. Waldman and the jury concluded that Ms. Heard was not credible. So basically what Adam is saying is what the jury found. The police came, there was no damage, there was no injury. Then somewhere between those policemen and the second set of policemen, Isaac came home, he saw some wine spilled, and then we saw pictures of some frames on a table and some wine on the floor. That was actually associated to more than one incident. So it made sense for Mr. Waldman to think, gee, the police came, there was no evidence of damage, no evidence of wine. Then they must have spilled some wine afterwards, which is what Isaac saw and took the pictures and then cleaned it up. Because when the second set of officers with the body cam came in, there was not a discernible wine stain in the hallway that they noticed. The fact that Mr. Waldman rejected Ms. Heard's version of events is not clear and convincing evidence of subjective knowledge of falsity. Citing a case, there must be sufficient evidence to permit the conclusion that the defendant in fact entertained serious doubts as to the truth of his publication. Well, the LAPD saw no wine spill. Isaac arrived afterwards, saw a wine spill that seemed fresh. Drew popped out of his apartment. The pictures apparently were from then. He must have cleaned it up because when the body cam, the LAPD with the body cam came. So that's what he based his statements on. He felt he was correct. Ms. Heard has not pointed to and cannot point to any evidence in the record to permit the conclusion by clear and convincing evidence that Mr. Waldman in fact entertained serious doubts as to the veracity of the April 27 Waldman statement. The lone judgment in her favor on the April 27th Waldman statement thus should not stand. And when I say Isaac, a reminder, he testified to this. So the jury heard that part. The April 27 Waldman statement is properly understood as opinion. Context is crucial in determining whether a statement is defamatory. In arguing that the April 27 Waldman statement is factual, Ms. Heard largely ignores that the statement was made to a reporter who wrote articles laying out statements from representatives of both sides of Mr. Depp's and Ms. Heard's dispute. Ms. Heard contends that statements by the journalist cannot render Mr. Waldman's statements less defamatory. That is not the point. The statement was made to a reporter who clearly recognized and presented it as a controverted opinion, not a factual statement. One lawyer gave their statement about the 911 call. Adam gave his rebuttal statement. Significantly, Mr. Waldman has never claimed firsthand personal knowledge of what transpired between Mr. Depp and Ms. Heard. Rather, the April 27 Waldman statement is commentary by a lawyer on the inferences to be drawn from conflicting evidence in a contested litigation, which was discussed in the article. The subject matter of Mr. Waldman's statements and Mr. Waldman's relation to that subject matter indicate that his statements were non-actionable opinions. Quoting from a case, there is a distinction between alleged libel that purports to be an eyewitness or other direct account of events that speak for themselves. On the one hand, and a mere interpretation of ambiguous events about which the speaker does not claim direct knowledge, on the other hand. Indeed, when a speaker offers one of a number of possible rational interpretations of an event that bristled with ambiguities, the United States Supreme Court has indicated that such speech is entitled to First Amendment protection as opinion. Adam reasoned. LAPD testified. They saw no damage anywhere, nothing. Isaac testified after the LAPD left, he saw a wine stain. There were photos. LAPD with the body cam came. We saw in the hallway that maybe there was a shadow, but nothing discernible for them to stop and go, ooh, gee, something got spilled here, suggesting they cleaned it up. And that's how Adam came to his conclusion. The Supreme Court has recognized writers must be given some leeway to offer rational interpretation of ambiguous sources. A commentator, this is quoting from cases, a commentator who advocates one of several feasible interpretations of some event is not liable in defamation simply because other interpretations exist, and remarks on a subject lending itself to multiple interpretations cannot be the basis of a successful defamation action. A reasonable listener would recognize Mr. Waldman's statements in context as a lawyer advocating for his client's position by providing a theory based on disclosed evidence of what happened, not a factual statement based on personal knowledge. The court should have instructed the jury on independent contractor theory. I'm big on this because I know a lot of the law tubers have covered the case. And I'll be honest, when I read those, just a personal, regular Joe who could have been a jury somewhere, I took those court instructions to suggest that they had already defined him as an agent, that they didn't give the jury a choice. Is it an agent or an independent contractor? This is me as just a layperson reading those instructions. That's just opinion. Whether a person is an employee or independent contractor can be determined as a question of law when, as here, the facts compel one interpretation. Otherwise, it is a factual question for the jury. On the facts of this case, Mr. Waldman is an independent contractor whose allegedly torturous conduct should not be imputed to his client. The judgment was, thus, erroneous as a matter of law. At minimum, there was sufficient evidence in the record to permit the giving of a jury instruction on this point. The evidence at trial established that Mr. Waldman represented Mr. Depp as an attorney in various litigation matters, but in no other capacity. And Mr. Waldman is the owner and managing member of his own law firm, which offers legal services to clients other than Depp. So that's an important point, because think of something like New York Times that gets sued for defamation. They have an entire in-house legal department. That will be an employee relationship. These facts plausibly support the conclusion that Mr. Depp's control over the details of Mr. Waldman's work was limited and could support a finding by the jury that Mr. Waldman was an independent contractor. A jury instruction on that issue would not have been duplicative, but would have rather appropriately focused the jury on the core issue, the level of control Mr. Depp exercised over Mr. Waldman. It is an error not to instruct the jury on independent contractor limited liability. Point 6. The trial court should have admitted the entire April 27th article. Now, picture in your mind, when they showed her op-ed, it looked just like this, right? Lines and lines of text. When they showed the jury the 3 articles with the statements, they were entirely blacked out, page after page after page, blacked out, except for his statement, period. No context, just black squares. Keep that in mind as you're reading this. Ms. Heard's argument that the April 27th article was properly admitted in redacted form misses the mark. The April 27th article was not offered for any hearsay purposes, but for 2 separate and significant reasons. 1, it established that the reporter did not accept Mr. Waldman's statement at face value, undercutting the motion that they were defamatory in context. And 2, it was relevant to assessing what damage, if any, Ms. Heard suffered. Without the full unredacted article, the jury was forced to speculate on damages without being able to make an informed assessment of the prominence of Mr. Waldman's statement in the April 27th article. Notably, the April 27 Waldman statement is contained in a Daily Mail article with the prominent headline, huge headline, exclusive, I need to report an assault. Listen to 911 call made the night Johnny Depp and Amber Heard had a blowout fight that ended their toxic 18-month marriage, but both claim tapes backs up their version of events. But both claim the tape backs up their version of events. The April 27th article lays out both sides, conflicting versions of events, noting that Ms. Heard's attorney says phone records and police department logs vindicate Heard's account of the final shocking episode of domestic violence she endured before filing divorce. Quotes. Whereas Mr. Depp's legal team say the recording does the precise opposite. However, by raising discrepancies in various accounts, Heard and her allies have given of the notorious dust-up. Quotes. It also describes Ms. Heard's various allegations of abuse, Mr. Waldman's rejection of their credibility, and the response from Ms. Heard's attorneys calling Mr. Waldman's statements fantasies. It is relevant to a damages analysis that Mr. Waldman's statement was not presented to the public as an uncontroverted fact. Moreover, as noted above, a relevant inquiry in assessing whether a statement is defamatory is whether the statement was made to someone knowledgeable about the facts and capable of recognizing the statement as an opinion, rather than an objective, reliable fact. The context of the article is evidence that Mr. Waldman spoke to a journalist that understood he was hearing one side of a story that had two sides, as the journalist presented both sides in the article. Further, the fact that the article contained so much additional commentary about both parties would have been relevant to enable the jury to assess the likelihood that Ms. Hertz suffered any actual damage as a result of the statement as it appeared in context, or whether any supposed damages were attributable to the many other statements in the article that were not at issue in Ms. Hertz's counterclaim for defamation. The full article should have been admitted. Conclusion. Mr. Depp respectfully requests that the court reverse the judgment in Ms. Hertz's favor on the April 27 Waldman statement and affirm the judgment in all other respects. Respectfully submitted from Ben Chu, Camille Vasquez, Jessica Myers, Wayne Dennison, the whole crew. Certificate of service to the counsel for Amber Heard. And that's all she wrote, guys. That's it. It now goes into a pile. My understanding is goes into a pile. And as others before it are heard, it'll eventually rise up in the pile. The judges will look at it and decide if they want to have a hearing. Now, I think they've requested a hearing. I know Rottenborn, who wrote the motion, the brief to oppose this, asked for a hearing. So we will see what happens. But that's the latest of the day. I hope you have a great weekend. I need to sign out. It's been a long day for me. And thank you for listening. And I really look forward to the LawTubers now take on this for this cold reading. Thanks all.